Good afternoon to everyone. My name is Sophie Kwasny. I'm the head of the Data Protection Unit in the Council of Europe in Strasbourg in France. It's my great pleasure and honor to welcome you today to this event, the 2021 Data Privacy Day event for the Asia and Pacific region. Today, 28th of January, marks the 40th anniversary of our Data Protection Convention that some of you know as Convention 108. It's a day to celebrate, and it's also a day to acknowledge what has been achieved in those 40 years. And clearly, being able to hold such a panel with you on this day is the perfect illustration of one of the achievements of the convention and what the convention represents, a global forum. And we're very pleased for that. In the last few years, the committee of the convention has been enriched by the participation of representatives from Japan, from Korea, New Zealand, and the Philippines. And aside this enrichment of the convention committee, I would like to mention as another achievement the successful modernization of Convention 108, because we're celebrating today a 40-year-old instrument. But since 2018, a modernized version, Convention 108 Plus, is available. There is now a reinforced system ready to be used by countries around the world and completely fit for purpose in our digital age. So Data Privacy Day, or Data Protection Day, as we say in my village, is a yearly opportunity to raise awareness on the right to data protection. I know it's an extremely busy day for you, and I really thank you for your time and your presence. It is already the 15th edition of this special day, which just like Convention 108 has crossed frontiers and continents. So today, for us, the Council of Europe, we're following the sun. We're starting this morning with you. Later today, we'll be holding a similar panel with African stakeholders. Even a bit later in the day, a European panel, and we will end the day in Latin America with Latin American stakeholders. Before we move to the discussion, just a few housekeeping rules. This event is being recorded so that we have a chance to have a look at the discussion later. Also share it with colleagues who could not attend. I'm of course asking you to mute your mics when you are not speaking. You have a Q&A option in the system. Please do not hesitate to use it. And without further ado, I would now like to introduce our two masters of ceremony. First of all, Professor Graham Greenleaf from the University of New South Wales, and Professor Hiroshi Miyashita from the Chuo University. I really need to highlight that with their precious support, this discussion and this panel would not have seen the light of the day. So thank you very much to both of you for your help. I will now pass the floor to Professor Greenleaf to present the panelists and give an introduction to the discussion. Thank you very much to all.
Thank you very much, Sophie, and congratulations to the Council of Europe for the 40th anniversary of Convention 108, which is a great achievement. So good morning, good afternoon, good evening, ladies and gentlemen, wherever you're located. As Sophie said, I will be the moderator for this first session. In relation to Convention 108, I'm the representative of the Australian Privacy Foundation as an observer on Convention 108 and have gained a great deal from my participation in it. We open the session today with four very eminent panelists in our first session, four privacy commissioners from the Asia Pacific region. First is we will hear from John Edwards, the New Zealand Privacy Commissioner, followed by Angeline Thorpe, the Australian Information Commissioner and Privacy Commissioner, then Raymond Liboro, the Philippines Privacy Commissioner, And finally, from Zikin Yong, the Deputy Chair of the Singapore Personal Data Protection Commission. Now, each of our commissioners is going to make 2 brief presentations, brief in that they have to be under 5 minutes duration. The first presentation will be largely on national developments of significance, and the second 5-minute presentation focusing more on international developments and the participation of their officers in those international events, including, of course, in relation to Data Protection Convention 108. And then we'll proceed to a number of questions that I'll put to the commissioners, to all the commissioners, and we'll see if we can get some discussion going around some of those things. So without any further ado, I'll pass over to New Zealand Commissioner John Edwards.
Thank you, Graham. And thank you, Sophie. Hello to my fellow panelists and friends and colleagues. And thank you for the opportunity to be present amongst and to address such an esteemed group of colleagues, experts and observers. I would like to particularly acknowledge those joining from Europe and experiencing what is commonplace for us in the Asia-Pacific region, which is inhospitably scheduled conference calls. At almost every conference I have attended since becoming Commissioner in 2014, I've heard calls to harmonise privacy laws, to make them interoperable, to bring them closer. World Bank, which is hardly a bastion about data protection, in a 2017 World Development Report called Digital Dividends, highlighted, among other things, the need for consistent, reliable regulation for data protection as a key factor in reducing inefficiencies, promoting consumer confidence in the online world. And we've seen the enormous cost and inconvenience when the regulatory systems are incompatible with the business information flows. TREMS 2 comes to mind. It has made this issue even more pressing. So where is this consistent, reliable regulation to come from? The OECD, the GDPR and its satellite adherence, or the APEC CBPR framework, perhaps? Each of these has advantages and disadvantages, but none constitutes international law in quite the same way as a binding treaty. Convention 108, it seems to me, has great promise and something of a head start in filling this legal lacuna of international law. But there are challenges. In 2017, I asked my staff to identify any impediments to New Zealand acceding to Convention 108. We concluded that accession would be possible and that there would be advantages to New Zealand from signing up to 108. These advantages included accession to a binding treaty guaranteeing a minimum standard of domestic human rights protections and underpinning domestic privacy law, maintaining New Zealand's reputation for having best practice privacy laws and our general commitment to human rights, and the status of being a treaty member proving useful in ensuring New Zealand is more easily recognised as meeting future tests of data protection adequacy. We obtained observer status to bring us closer to the workings of the Convention and to assess what the benefits of accession might be, and began a program of work to prepare for me to make a recommendation to our Prime Minister to accede to the treaty. 3 things were happening in parallel with that work. The European Commission was finalising the preparations for the GDPR to come into force. The New Zealand government was working on implementing privacy law reform that had been recommended by our Law Commission in 2011. And the Council of Europe was considering modernising the Convention to become 108 plus, as Sophie mentioned a moment ago. While the New Zealand law reform brought our law closer to the GDPR, it did not bring us as close to that standard as 108 plus would reach. We added in our law that came into force on 1 December last year, mandatory breach reporting, stronger enforcement powers, and restrictions on trans-border data flows, but did not go so far as rights to object to automated data processing, mandatory impact assessment, or special categories of personal data. These differences are enough to preclude New Zealand's accession to 108+, even though I would argue that New Zealand law provides a standard of protection for individual rights as comprehensive as any 108 signatory. If Convention 108+ is to meet the need for a truly international treaty on data protection, it may be that the Council should give more thought to providing for signatories to accede with reservations, or to accede on the understanding that they join as an indication of intent to fully enact domestic law in line with treaty obligations. If Convention 108+ could be seen more of a pathway than a destination, it may be that more jurisdictions would see the benefits of that accession and that we would build and support this important piece of international law. Thank you, Graham.
Thank you, John. You're an exemplary opening speaker because you've kept under 5 minutes. So thank you for that. I'm going to allow myself one comment on what you had to say, and that is that I suspect you may be being too pessimistic about the standards for accession to Convention 108+. Because if we look at the history of accessions to Convention 108, the 8 of them so far, we find that quite often particular strengthening of national laws was taken pretty much as a promise that it will be enacted before too long, and not every single box on 108 was ticked off by every single applicant for accession. So perhaps, but anyway, you've opened up a wonderful stream of discussion for us, and perhaps when you come back for your second slot, you can tell us what happened to that request you were making to the Prime Minister. But for now, we'll move to Commissioner Angeline Falk of Australia. Angeline, over to you.
Thank you very much, Professor Greenleaf, and thank you for the opportunity to speak with you all today on this very important Data Privacy Day. And thank you to Commissioner Edwards for framing up the discussion today. I think at the heart of what Commissioner Edwards has drawn out is this conundrum about interoperability and what is the way forward to ensure that we have strong and common frameworks globally into the future. And I'd like to give a couple of reflections about that by reflecting on the Australian domestic context and a major reform and review of the Privacy Act that's currently underway in this country. At the start, I should mention that Australia is an observer to Convention 108. Of course, the issue of accession to the Convention would be one for government. The comments that I make today are as the National Privacy Regulator, and as that National Privacy Regulator, my remit extends, of course, to regulating the conduct of global entities, many of which are not incorporated in Australia, but nonetheless handle millions of Australians' data. And so I've experienced firsthand that in order to regulate in the global digital economy, regulatory cooperation is vital and central to our success. So today provides, I think, an opportunity for us to discuss and consider further how that international regulatory cooperation can be achieved. And when I look across the work of the Global Privacy Assembly and also regional fora like the Asia Pacific Privacy Authority, I think we can see that there is some consensus around what those indicia for global regulatory cooperation, success factors, if you like, look like. I think, as Commissioner Edwards said, we need a degree of commonality or interoperability in our legal privacy frameworks. We also need the mechanisms to allow enforcement cooperation and the sharing of information not contrary to domestic laws. And thirdly, we do need to cooperate as regulators when we develop policy positions and play our part to ensure a consistent interpretation of law internationally. In Australia, as I said, we are in the midst of this review of the Privacy Act. We have a well-established privacy framework that references the OECD guidelines and also the International Covenant on Civil and Political Rights. It's principles-based and technically, logically neutral and flexible. However, the scale and scope of environmental change that I think we've all witnessed has led to this imperative to review the domestic law to ensure that it is fit for purpose in the digital age and can meet the objectives of the Australian people into the next decade. So in terms of the review itself, I will just quickly share my screen if I can here and see if this works. Have we been successful?
Absolutely.
Excellent, thank you.
Oh.
So I've put on the screen a timetable of privacy reform for Australia. It follows a recommendation that my office made to our consumer and competition regulators' landmark review of digital platforms and the inquiry they conducted, where my office recommended the Australian government conduct a review of the Privacy Act. That recommendation was accepted. And there has been terms of reference and an issues paper released late last year. The review will be conducted by the Attorney General's Department, and we also expect a discussion paper to follow and for recommendations to be put to government towards the end of this year. So my office contributing our regulatory experience through making our submission, and we're focused on 4 key elements in this debate. The first is particularly relevant to this discussion, and that is global interoperability, but also ensuring as a regulator that we have the right tools to regulate into the future. And our recommendations have drawn very heavily from the experience of our international colleagues, whether it's the GDPR or recent or proposed reforms in Canada, California, and indeed in New Zealand, that bring us closer to interoperability with those laws and a consistent framework internationally. We're also mindful that the frameworks need to be adapted to Australia's purposes, as well as ensuring that we have that global perspective. And I'll just conclude in my last couple of seconds with drawing out some of the key recommendations that I've made to government as to where I think reform needs to occur. And of interest today, whilst Australia already has a number of very strong protections, including mandatory notifiable data breach, my recommendations would bring us closer to alignment with the requirements of Convention 108+. They are the right to object and erasure, strengthened demonstrable accountability obligations, extending fairness obligations and a new introduction of reasonableness standards, and also removing some exemptions which currently limit the application of Australia's privacy laws. Thank you. I'll conclude there, Professor.
Thank you very much, Commissioner Falk. And your references to the importance of interoperability will certainly be a matter of further discussion through this morning in reference to Convention 108. So, and thank you for keeping to time as well. So we'll now move to our third distinguished commissioner, Raymond Liboro, the Philippines Privacy Commissioner. Over to you, Commissioner.
A safe and healthy day to everyone, especially to you, Professor Greenleaf. It is an honor to join all of you in this virtual celebration of International Data Protection Day. And congratulations too to the Council of Europe on its 40th anniversary of Convention 108. We may not be physically present with each other right now, but I know by this time, after almost a year in this pandemic, we have all adjusted to virtual meetings and dialogues. Technology and data are continually changing the way we live. And this is especially true as we face the COVID-19 pandemic. With the global health crisis, personal data has never been so valuable. As a privacy authority in the midst of a pandemic, it is not only the misuse of data that concerns us, but also its misuse. As such, we have guided stakeholders in the government and the private sector not only here but abroad, as head of the Global Privacy COVID-19 Working Group on the best use of data and handling of personal data in this time of the pandemic. As a data protection authority, we try our best to be enablers and protectors and prove to everyone that public health and data privacy are on the same side. Without a doubt, COVID-19 is a historical conjuncture. It has accelerated digitization everywhere, digitally enabling citizens and boosting data flows worldwide. But unprecedented use of technology and data makes me more confident that humanity would eventually find a cure to this pandemic. But lowering our guard during rapid tech development and deployment, digital experimentation, and disregarding human rights and privacy principles by design will bring risks and potential harms due to cyber and privacy threats to our citizens. That is why, as a data privacy authority, we are committed to protecting rights or ensuring the free flow of information. We believe data for good must flow openly to reduce transaction costs and lessen the friction for products and services to reach customers in a high-trust environment. Therefore, DPAs must understand that it is essential to establish a conducive and consistent regulatory space that promotes innovation, a level playing field, and business certainty, while ensuring that the fundamental human right to privacy are upheld and protected. DPA must continue to encourage companies to be accountable to their customers and hold accountable those who refuse to be responsible and expose citizens to harm. The critical point is for DPAs to find that balance between maximizing the beneficial use of data and ensuring that citizens' public interest, legitimate privacy concern, and their human rights are met. Equally important is for DPAs to be transparent in their guidance to the industry and what to do. In the Philippines, we have embarked on building trust through a clear roadmap. It starts by building resilience at the firm level and then leveling up to demonstrate accountability locally, regionally, and globally to deliver and receive data across borders seamlessly. In 2018, we launched our Data Protection Officer Certification Program and ramped up our involvement in the ISO. The NPC is among the loudest voices to commit as a participating member in the ISO working groups developing international privacy standards when the standards body started introducing significant privacy and information security related work items in 2017. This year, we will introduce the Philippine Privacy Mark, informed with international standards from our ISO participation. The Philippines aims for global standards and is working towards harmonization in the region and not creating our own privacy bubble. This year, the Philippines became the 9th APEC member enrolled in the APEC Cross-Border Privacy Rules System, or CBPR. The National Privacy Commission is also closely working with the Association of Southeast Asian Nations, or the ASEAN, in developing the ASEAN Framework on Digital Data Governance. The framework seeks to enhance data management, facilitate harmonization of data regulations, and promote intra-ASEAN flows of data. In 2019, we signed a bilateral agreement with Singapore's Personal Data Protection Commission. We have committed to harmonizing legal and regulatory landscapes in the region and developing and adopting the best data protection and privacy practices. The NPC will continue to pursue and expand its involvement in existing regulatory cooperation modes to build trust, especially in cross-border data flows. Privacy movers in the Asia-Pacific region, notably Australia, New Zealand, and Singapore, understand that the speed at which threats evolve will almost by definition always outpace our combined ability to prevent them. By its very nature, securing our systems against malicious attacks is a cat-and-mouse game, where the mouse still has the initiative. And as disruptions happen at all levels, governments, the private sector, and individuals should all the more consider the potential risks and harms linked to the misuse of personal data. We also understand that rights and value in today's data-driven world, specifically in 2021 AD, or after the disease, will be created by building bridges and not walls. How then do we create that environment of trust?
Could I ask you to keep the rest of your remarks to your second instalment, please, so we can just keep everyone to time? Just another minute or so now.
Oh, I'm sorry. All right, Professor. Yes, and you just then I thought I'm ready on the delivering stage, but definitely let me stop at this point.
Another good opportunity later.
Okay, let me stop at this point. But I promise you, the tender line will be the second part. Thank you.
Thank you. Right. So, well, ladies and gentlemen, we now move to our fourth commissioner, Zikin Yong, the Deputy Chair of Singapore's Personal Data Protection Commission.
Thank you. Thank you for the opportunity for me to come and share a few thoughts about Singapore's view, right, on interoperability and also some updates on what we have done recently as we updated our Personal Data Protection Act, our domestic law. I think we've always looked to leaders, pioneers like the Convention 108, the OECD guidelines, to see what are the core principles that were established by these pioneers in the field of data protection, how they have defined the early contours, and how they set the trajectory for the developments of data protection law. One of the things that we did in the recent review of our domestic law was to take a look again to see what are the modern changes that have come on. And of course, we looked at the GDPR, and latterly, we also looked at the California laws, right? The things that even without a formal treaty, even without a formal attempt to harmonize, modern data protection laws take reference from each other, and there are a lot of similarity. The core principles are similar because essentially all our laws have common objective of protecting consumers and encouraging good governance and accountability. So it is not surprising that we take the best from each other and we inadvertently, unconsciously, or maybe deliberately actually converge on these core principles. But we also recognize that there is a need for divergence to accommodate the variations across cultures and histories and societies, and particularly in a diverse region like Asia. So with that setting the backdrop, what I'll do is maybe just share a few headlines about what we did as we amended our data protection law. We were, of course, very inspired by the GDPR, and we looked to see what new innovations there were that were useful and that was helpful, right? We also saw global trends like the mandatory notification of data breach. So essentially, we put them together, and in a nutshell, I would describe that we made three sets of significant changes to our data protection law. We doubled down and strengthened our commitments to accountability as a principle, and we specifically recognized it in our Data Protection Act. We enhanced our enforcement powers, right? And we introduced a regime for mandatory data of encouraging and instilling accountability and responsibility in organizations over the personal data that they possess and they control. We also had to review and revise the legitimate users of data that our Act recognizes, because some years has passed, technology has moved, business models has changed, consumers' expectations have also evolved. So we review and revise the legitimate users that's recognized through exceptions or concepts like deemed consents to really modernize the concepts, right? Because it has to continue to be relevant to both consumers and businesses. And finally, we strengthened consumer control over their personal data, and we introduced the concepts of data portability, right? And we modernized our law as well by recognizing that there are more business communications channels in use these days. Instant messaging on mobile phones is one of those things that we actually recognize as a business communications channel, and we extended our spam control and do not call registry provisions to give our consumers control over how they receive communications through these channels as well. So as you see, even though there is no formal attempt, I think that we are all converging to the core set of principles that are relevant and useful for our consumers and for our business. I think I would reserve my further remarks about what we've done in the global and regional scene like APEC, ASEAN for the second set of remarks that I will make later. Thank you for your attention.
Thank you very much, Sikin, and thank you to all of our commissioners for keeping to time. We're going well, and we can now move to our second, more internationally oriented round of discussions, starting again with Commissioner John Edwards from New Zealand. And John, just before you start, I thought I might mention that because your office is an observer on Convention 108, and you've participated in some of the consultative committee meetings in Strasbourg. Perhaps you could just, in the course of your remarks, touch on what you've gained and what you feel New Zealand has gained from that participation.
Well, what a prescient intervention, Graham, because that was exactly what I was proposing to do in my brief comments. But I don't have 5 minutes. I'll be able to donate some of my time to my colleagues. But in my earlier remarks, I set out what I saw as the main advantages to New Zealand acceding to Convention 108. I didn't mention a very practical one, which is the opportunity to attend and participate in the plenary sessions of members with the committee. While there are a number of fora for commissioners to meet and discuss matters of common interest, the Convention 108 plenary is quite unique. The main forum for data protection authorities and privacy commissioners is the Global Privacy Assembly. But we also have regional groupings of great value, such as Asia's Pacific Privacy Authorities. And there are other multilateral organizations which have privacy and data protection working groups or substreams, such as APEC and the OECD. But what's unique, it seems to me, about Convention 108 and the plenary sessions is that it is a truly multi-stakeholder gathering, including government, industry, academia, and civil society, as well as commissioners. And these members all get to participate in the discussion and contribute to the instruments, declarations, and workshops that the committee produces or conducts on emerging issues from genomics to artificial intelligence and autonomous vehicles. New Zealand has, as an observer, has an equal part in those discussions. So accession is not a precondition of participation in those conversations. That means that everybody gets an equal seat at the table. We're not the passive recipients of rules or guidance that are foisted on us. We can all contribute equally and bring that all those different perspectives to that discussion. But Graham, you mentioned in our Twitter exchange that I might leave open this second spot for questions, and I'm happy to do that and to hopefully have a more rich discussion. I will just return to the point that you asked me after my initial presentation, and that is, how did the Prime Minister react to a recommendation? And the answer to that is that we never made a recommendation. We didn't feel that we were able to recommend that the government accede to the convention if it could not, in good faith, guarantee that the domestic laws met those international obligations. So having had an initial assessment under Convention 108, which was that we would have been able to accede, when we reassessed under 108 plus, we made the determination that there were areas where we would not be meeting our legal obligations and therefore did not feel able to recommend accession at that point.
Thank you very much, John. John, I won't take questions directly to you right at the moment. We'll move through the other three commissioners first, but thank you. You're making sure that we do have time for questions at the end of the presentation. So we'll now move to Commissioner Angeline Thorpe for her second lot of comments.
Thank you very much, Professor. I'd like to make some comments about international cooperation from two perspectives. The first is the role of the Global Privacy Assembly, of which I'm a member of the Executive Committee and Chair of the Strategic Direction Subcommittee. And second, in my solely domestic capacity, the various methods that my office uses to facilitate cross-border regulation. And then perhaps in question time to conclude with some reflections on how Convention 108 might contribute to that cross-border cooperation. So wearing my international hat as the member of the Executive Committee of the GPA, I wanted to refer back to the three features of regulatory cooperation that I referred to in my first presentation, and to share with you how the GPA is contributing to those three aspects of regulatory cooperation and the factors that I consider are required for success in that arena. You'll see on the screen a series of circles which indicates the pillars that have been established for collaborative work by the GPA. And one of the strategic priorities of the GPA is to facilitate an environment with clear and consistently high standards of data protection. And of course, global cooperation is at the heart of achieving that goal. The global frameworks and standards circle that you can see there represents the work that our working group is doing last year on analysing 10 different regional and international frameworks, including Convention 108 for points of commonality. And there were many. And I think that exercise has again demonstrated that there's more that unites us than that differentiates us in those frameworks globally. The second is the enforcement cooperation work done by that working group, where the GPA is providing a forum to members to work collaboratively on regulatory activities, importantly share pragmatically regulatory tactics and methods, and also to workshop regulatory challenges. And it does provide pragmatic and practical outcomes. So an example is last year the working group issued communication to video conferencing providers to set out expectations of data protection, particularly when the pandemic first commenced and the utility of and utilisation of those mediums became much more prevalent. And the third is around policy themes. And as I said in my first presentation, there are data protection authorities who rightly around the globe are grappling with policy issues, whether it's around human rights and social protections or economic governance and the digital economy. This work of the GPA provides an opportunity for convergence and again to have useful work that results in practical tools and mechanisms that members can use to inform their own work domestically. So it also supports that greater convergence where appropriate. It enhances consistency and predictability in the system of regulatory oversight for the benefit of individuals and for regulated entities globally. Turning now to the domestic point around how my office works collaboratively internationally, more and more files that come across my desk are about global corporations, and more files are about data handling practices that have the potential to cause harm, not only to citizens within Australia, but across borders. Issues like profiling, tracking, monitoring and targeted advertising of children online, the scraping of personal information from online platforms. So one way we've sought to address this issue is through joint investigative initiatives, and in March last year, my office announced a joint investigation with the UK Information Commissioner's Office, utilising the global cross-border enforcement cooperation arrangement and also pursuant to an MOU arrangement with the UK ICO. We've also carried out cross-border enforcement work with the FTC and also with Canada, utilising the cross-border privacy enforcement arrangement, particularly in relation to the Ashley Madison matter. But more recently with Canada, a number of matters where we are cooperating around issues of common concern. So there are these other frameworks that exist. And so I think the next question for us to consider is how Convention 108 can add to that landscape and how it might enable greater sharing of information for regulatory cooperation. And noting the time, I'll leave my remarks there. Thank you, Professor.
Thank you very much, Commissioner Falk. Now we'll move to Commissioner Liboro for his second round of comments.
Okay, thank you again, Professor Greenleaf, and my apologies again for stretching the first part of this meeting. You see, as ASEAN member states, the Philippines included, have come later than others to the privacy discourse party. But this came with some advantages. It allowed us to put up systems and processes that are already informed by the experiences of others. It allowed us to put the best practices from all over, so that our data privacy regime does not need to go through its disasters to acquire knowledge. That's why I also share, again, the narrative as presented by Singapore's Commissioner Zikin. But at the same time, we enrich our practices by applying concepts from other fields and our own experiences in an interdisciplinary approach. And this is how we put privacy resilience into practice. And I really see it as the Asian contribution to the global privacy discourse. On March last year, the APEC Cross-Border Privacy Rule System Joint Oversight Panel approved the Philippines' application to join the APEC CBPR. The Philippines became the 9th APEC economy to join the CBPR system, joining United States, Mexico, Canada, Japan, South Korea, Singapore, Chinese Taipei, and Australia. This year, the NPC signed a Memorandum of Understanding with its counterpart in the UK, the UK ICO, to formalize our bilateral partnership to ensure while fostering innovation and business growth. The Philippines' participation in Convention 108 and the Modernized Convention 108+ bring about significant learnings and insights concerning the formulation and implementation of data protection policies in the Philippines, thereby ensuring compliance with international standards set for data protection. Through our participation in Convention 108 as an observer, the Philippines is provided with a platform to coordinate and exchange ideas with other data privacy experts and regulatory agencies to ensure practical data privacy standards and policies. Thus, I totally agree with you, Professor Greenleaf, when with your opinion that there are benefits that countries outside Europe can obtain from accession to the Convention, a few of which are accession provides international best practice recognition, transnational organizations in fields such as policing, humanitarian assistance, etc. They need to adhere to minimum privacy standards. Accession to the Convention also helps ensure that they do. And I must say that our participation in Convention 108 meetings have helped us tremendously in dealing with other sectors here, particularly the government, the law enforcement sector, and the standards that have been discussed in the committee level in the Convention 108 have helped us tremendously in coming up with codes of practices for our law enforcement group. So this year and beyond, the Philippines intends to strengthen our involvement in the Convention by taking steps towards succeeding. This move will help ensure that local international agencies and entities dealing with Philippine citizens and residents' data institutionalize effective privacy programs to meet the Convention standards. And more importantly, this would also provide the NPC with the power to enforce compliance to the same. We think Convention 108 is essential for global data privacy resilience. to foster, to guide and support nascent jurisdictions, upcoming networks, and expanding privacy regimes, to build a strong, responsive, and resilient privacy architecture to protect all our citizens. Thank you, Professor.
Thank you very much, Commissioner. And now we'll move to our final presentation by the Commissioners, from Zikin Yong from Singapore to his second set of comments.
Thank you. I'll turn a bit now really to interoperability and the work that that Singapore is doing to contribute to achieving this in the short term. I think that's one of the we need to look at these issues. I see at 3 layers, right? There is attempts to harmonize at the legal framework, the regulatory framework layer. And I think that is going to be an uphill task and a challenge, right? Given the huge spectrum of diversity in the readiness and even familiarity with the concepts of data protection, and even having data protection laws across the globe. Moving to the next layer, we can start thinking about convergence of practices at the administration of data protection regimes, particularly amongst those with an interest to introduce the laws, and also for those who already are administering and enforcing the domestic laws. And this is the area that Singapore has paid most attention to, right? We've been quite active in ASEAN, right? The Association of Southeast Asian Nations, together with Raymond, right? So over the last few years, the introduction of data protection principles in ASEAN, and the digital data management framework, and very recently, just a couple of weeks ago, the introduction of model contract clauses at the last ASEAN meeting. We acceded to and have been active in the APEC cross-border privacy rules and the privacy rules for processors as well. We are part of the JOS that administer this, and we've been active in signing up a company. On APA, a meeting. We are also contributing as much as we can, and of course Japan. So I mention these because I think that while it is ambitious and just eventually necessary for some form of harmonization at the regulatory and the policy level, work can begin by convergence of practices in administration and enforcement, and that's probably where we can get most mileage, working together with fellow data protection regulators and authorities. I wish to leave some thoughts, some provoking thoughts on the third layer. How can we, as data protection regulators and administrators, help promote interoperability at the business technology and business operations level as well? Because while we are able to, we speak from our different silos of atop our domestic laws, multinational companies and even our enterprising startups operate on a global scale, and they operate across multiple countries, multiple markets, multiple jurisdictions. So they need to grapple with this. And the view that we've taken is to see whether through the use of certification systems, we are able to help in that process. We introduced our data protection certification mark 2 years ago. We've signed up 42 companies since then, with the same number in the pipeline. But really the focus is to see what we can do to understand the business operations and processes better, to recommend common off-the-shelf solutions, recommend template processes, so that by the adoption of these practices and these solutions by companies, we are achieving real interoperability. And that actually comes back to my point earlier, that we all have common goals to protect consumers, good governance. Perhaps by starting from the ground up, working with businesses, standardizing processes, adopting common off-the-shelf solutions to help them adopt good internal governance. That actually will build the foundation for eventual convergence and harmonization at a higher level. So I'll leave with these thoughts, and I hope to that we will be able to build on these later in our discussion. Thank you.
Thank you very much, Sikin. And I want to thank all the commissioners for letting us have an insight into the quite extraordinary range of international activities that all their officers are involved in. We have about 10 minutes before I hand over to Professor Miyashita for the second part of this session. And so I'll direct a couple of questions to all the commissioners around Convention 108. But the first question is really more directed to Sophie Kwasny, who I hope will be able to give us an answer. And it's triggered by the fact that, of course, it's very difficult when you're coming from New Zealand or the Philippines or Argentina or Mauritius to be able to go to Strasbourg perhaps more than once a year to participate in plenary meetings of the consultative committee. It's a lot easier for people in Europe. But last year, because of the pandemic, the second plenary of the year was held completely online using this Blue Jeans software that we're using now, which among its other virtues allowed for simultaneous translation from English to French or vice versa of all verbal inputs from participants, and also simultaneous translation of all the Q&A that was going on, the discussion in the chat. And it seems to me that this presents a really good model after the pandemic's over as well for the globalisation of Convention 108. If we could have plenary meetings that were partly in person for those who can be there and want to be there, but still allowing participation from all the remote parties and observers to Convention 108. So, Sophie, perhaps you could tell us what the plans are in relation to future participation.
Thank you, Graham. The first thing I'd like to say is that Strasbourg can be a very, very far away place, but you know it's worth the travel.
It's a nice place.
And indeed, we've been constrained and forced this year to move to those new tools enabling us to meet at a distance. It's not been easy, for instance, finding platforms with interpretation services because we have 2 official languages, so all of our work has to be done in those 2 official languages when it's statutory work. And indeed, we've seen that it worked with the technical glitches that we're all used to. It worked really well in the sense that it enabled a much broader participation to our plenaries than we had ever had for obvious reasons, because precisely of the travel constraints normally. And it's definitely something we have decided to keep, hoping to be able to welcome visitors to Strasbourg again for physical meetings, but maintaining the hybrid format. So those who can come and travel to Strasbourg will meet in Strasbourg, but we will be keeping a format where we can engage with the observers and the members that are far away. So it's definitely one of the value of this year we've just been through.
Thanks, Sophie. And so I'd like to ask whether any of the commissioners might like to comment on what Sophie's just said is really a new advance in Convention 108's globalisation. No comments? I think we can take it they'll all be happy about it though, Sophie. So I'm now going to put a second question to any of the commissioners who might like to comment, and that is you've all talked a lot about the different mechanisms that assist interoperability. Well, there's one unusual one that comes out of Convention 108. And in various ways, the two countries I've seen that have adopted it have been Russia, which is a party to 108, and Israel, which is not. But in both their laws, they have provisions that essentially say they will allow data exports of personal data to any countries that are parties to Convention 108, thereby doing away with the necessity to draw up their own white lists, as it were, but accepting that the processes to decide who can be a party to Convention 108 will satisfy the requirements for them to allow a free flow of personal information. There are provisions as well in the Convention for you to dissent in relation to particular countries, but that's the basic idea. So I wonder, would any of the commissioners like to comment about whether that radical move would be a valuable step for interoperability? Without making any commitments on behalf of your governments or anyone else.
Graham, it is an interesting idea. Who will you call on, Graham?
You're muted, Professor Greenleaf.
I'm sorry. I wasn't calling on one particular commissioner, John. I was opening it to the four of you, to whoever wished to comment. But if you would like to start, then please do so.
All right, thank you. Look, I think that's a really interesting idea, and it has potential to resolve a problem. But there is another problem, an elephant in the room, isn't there? Which is that those jurisdictions that are bound by GDPR still have the obligation of adequacy and still have the ECJ Schrems limitations hanging over them. So a decision to allow data exports to any signatory nation might come into conflict with that. And it would be interesting to hear from Sophie, perhaps, about the relationship between the European Commission and the Council in this regard, and the sort of coordination of approach.
Professor, might I just make one comment before perhaps we hear from Sophie?
Please do.
Thank you. So just following on from Commissioner Edwards' remarks around the relationship between the GDPR and Convention 108, I think one of the things that I think can be a real advantage of an international treaty is to facilitate greater cross-border cooperation and collaboration, particularly if it has a force in domestic law that gets rid of one of the problems that we have in some jurisdictions, and that is where some domestic laws don't really allow the sharing of information between data protection authorities. I'm interested to know, though, how the extent of that regulatory cooperation might manifest. So we know that the EU has particular processes through the European Data Protection Board where there's a lead regulatory authority, and those processes are subject to confidentiality as between those data protection authorities. There is an ability to have cooperation with third parties, which could be facilitated through Article 50 of the GDPR. However, we haven't yet seen that implemented, and I remain unclear as to how Convention 108 might intersect and operate in practice with that third party ability to share through the GDPR. Thank you.
Thank you. I think they're really fruitful and interesting questions that rarely get explored. Now, would either of our other two commissioners like to make any comment on this particular question?
Yes, Professor. Yeah.
Go ahead.
Professor Greenleaf, yes, let me just pitch in. Again, that's a very interesting proposal, the table, if you may call that. But again, let me derive a few points from why my colleague, Commissioner Zikin, as he mentioned, we are working regionally here. You might call it our own regional network or network called the ASEAN. And we have 10 member states, and this year we're expecting two of the largest archipelagos to probably be at the table too, and that's Thailand and Indonesia. So you are looking now at the ASEAN, whose combined population would probably even exceed that of the EU's, with the entry of again Thailand and Indonesia. And currently we have 3 members who have laws in place, and you have Singapore there and Malaysia. That's why Zikin mentioned a very particular aspect, a very important aspect of what we're doing right now, and that's really instituting firm level accountability, compliance, and building resilience on the companies. And if we don't have, we don't have the laws, all our members don't have the laws in place. So we are really looking and finding the most common thread that we can all handle on to, just to be able, again, for us to, effectively still protect our citizens as their data process borders. So we are introducing a certification scheme for privacy practices here, and also model contract clauses for our company. So these are again really granular approaches of building again company accountability. The message is, even if the different jurisdictions, they don't have the laws, the proper law, the comprehensive laws in place, we can still strive to protect our citizens in whatever way. And these are the ways that, if you will look at it, have been culled from the practices of the EU. Right, and GDPR, and you're talking of model contract clauses, right, and right now certification. So we just shouldn't stop looking for all this. I think the common thread that will then finally, hope that this will all be connective tissues. As we've mentioned, I think the ambition is the same, to protect our consumers, to protect our citizens. But right now in this pandemic, this idea and this ambition. The bright side here is that not so many other jurisdictions now are pursuing this, and we will see that, I think, and this is really a conjuncture. We will now see bigger jurisdictions coming into the privacy game. So we really just have to look for these common threads. Thank you.
Thank you very much. Now, Zikin, I'll give you the opportunity to make a comment.
Yes, I just wanted to share perhaps my view on what the example you raised might actually signify. My own view is that to converge or to harmonize on one global treaty in the short term, even in the medium term, is probably difficult. But we do see attempts to come together around a few standards, perhaps regional, right? But that might build the case and build the momentum for an eventual global standard. Just as the examples you raised about Russia and Israel pointing towards the Convention 108 class, I also want to raise examples led by Singapore, where we recognize a certification, the APEC CVPR certification, in and of itself as a transfer mechanism, and to allow the transfer of data to other certified companies that way. And I think that if other APEC CVPR countries implement their domestic law in a similar fashion, we will start building up a group of economies around that as well. And I think that as we come together within regions and as regions converge, that will set us up very nicely to take the next step for a more global and uniform convergence. So I think these moves are be encouraged, and I'm really supportive of that. Thank you.
Thank you, Ezekiel. We had better wrap up our session now because we're a couple of minutes, only a couple of minutes, fortunately, over time. And I'd now like to hand over to Professor Hiroshi Miyashita to convene the second session of today's event. And thank you very much to the four commissioners. We can all give them a virtual round of applause. Thank you. Over to you.
Well, thank you very much, Graham, and the four commissioners for your inspiring remarks. So let me move on to the second session for a discussion period to deepen our understanding of the Convention 108 and the updated version, and also the international environment of data transfer and data protection. So happily, we have three experts in our Asian regions. So each three speaker will give their impression, his or her impression and thoughts, remark for 5 minutes. And then we would like to open up questions to the audience. So first, Professor Anne Chen. Professor Chen is a professor of law at the University of Hong Kong. Professor Chen's academic interests are in freedom of expression, privacy, children's rights, and law and society studies. So Professor Chen, over to you.
Good morning. Good morning, everyone. I will start sharing screen first. Let me take care of that. Can I ask, can you see my screen?
Yes, it's working.
Thank you. Thank you. Good morning, everyone. Thank you so much for having me here today. I trust that most of you know about this song, Torn Between Two Lovers. So I use this as my title. Other than bringing some good old memories, I would like to highlight the challenges and due demands that Hong Kong has to face under the European data privacy regime and an emerging new one from China, and to show why a harmonized approach like the Convention 108 is essential in global digital economy. Although Hong Kong is not a signatory to Convention 108, but it was the first jurisdiction in Asia to have comprehensive data privacy law. We have the Personal Data Privacy Ordinance back in 1995, implementing the OECD guidelines and EU directive, embracing the fundamental values in Convention 108. So far, we only had one major revision back in 2012 on the issue of direct marketing. The reform of our law is long overdue. We have a section governing cross-border data flow, but it has not been effective. Most of us are familiar with the new requirements under the GDPR. Equally, China has a proposed set of new requirements which arguably has extraterritorial effect, and Hong Kong has to comply. Other than the fact that Hong Kong is a special administrative region under one country, two systems, that Hong Kong is also one of the cities in the Greater Bay Area project. That is, supposedly we have to strengthen our economic and social cooperation ties with other 10 cities in southern China. I mentioned about the extraterritorial jurisdiction of China's privacy legal regime. It was 1 year after the GDPR has come into force in 2018, we witnessed a rapid acceleration of data privacy laws in China. I have highlighted three of them on the site, and in general, Chinese laws do not have extraterritorial effect. However, The draft Personal Information Protection Law will apply not only to the processing of personal information of natural persons within China, but will have long-arm extraterritorial application to any personal information processing activities of organizations carried out outside China and falling into one of the following circumstances listed on the right-hand side. So seemingly, the emerging data privacy regime shows influence from Europe, and China has taken progressive steps to include international principles of privacy and data protection laws. But this has with its own strong characteristics, focusing on cyber sovereignty, with strong emphasis on data localization and long-arm jurisdiction, and separation between privacy from private actors and privacy from the government. The proposed Chinese model, together with the requirements under the Euro, will likely cause many corporations to be extra cautious when it comes to data privacy compliance. Hong Kong, as an international financial city, will have to face dual demands from her two lovers, Europe and China. Perhaps in the age of digital economy and globalization, it's inevitable for state to protect the data of its citizens and to exercise long-arm jurisdiction. Hong Kong will not be the only jurisdiction to face the demands from her lovers. Hopefully the lovers can agree on harmonized standards and a common framework that is discussed earlier this morning, like the Convention 108. So I end my presentation here and take questions later. Thank you.
Well, thank you very much for your excellent intervention, Professor Chen. So now I would like to invite Professor Kyung-Sin Park. Professor Park is Executive Director at OpenNet Korea and Professor at Korean University Law School. He has been active in the area of internet, free speech, privacy, defamation, copyright, and international contracting. Over to you, Professor Park.
Thank you. Thank you for organizing this event and giving me an opportunity to participate in the discussion. I think the main benefit of Asian countries of acceding to Convention 108 or 108 plus is clear. It is that people in those countries will be protected better, more strongly on important right, which is data protection rights. Many forget that Convention 108 series originated from discussion on whether European Human Rights Convention of 1950 was sufficiently protecting human rights, and that Convention 108 is really a human rights treaty. So from people's perspective, it is very clear that we should prefer our governments we should persuade our governments to accede to Convention 108 series. So having said that, I'm happy to remind the audience that back in November, the Korean government, which is still an observer in the consultative committee, has announced that. So I hear we OpenNet Korea is now an observer, but was not an observer back then. So we didn't hear it firsthand, but we heard that the Korean government has announced their intent to join the convention. Right? I want to talk a little bit about the issues and challenges in such accession process. Korea has failed European Commission's adequacy decision twice already in the past decade. For the main reason was that we don't have independent Data Protection Authority. Previously, Data Protection Authority was a committee that is part of Interior Ministry, and it has, as you know, failing adequacy decision, cross-border transfer of personal data of EU citizens out of EU is restricted, and we are happy to report that February not this year, now it's last year, February 2020, we re-established Data Protection Authority as an independent ministerial level agency that has its own personnel and budgetary authority with 3 times the size of the personnel than before, and it has received in its it has acquired data governance functions of other agencies, communication agency, financial agency, and Interior Ministry, and other agencies under one roof. So we believe Korea is ready, at least on the paper, to both to attempt to pass the adequacy decision as well as join Convention 108. Now, having said that, what's on the paper is not enough to. I mean, what's on the paper is often different from what's different from the reality on the ground. What does it mean to have a strong data protection law? Even though Korea has a very strong data protection law, when it comes to the restrictions on data usage, we have very detailed provisions governing abuses and data breaches. And at the same time, we also have this creative system of dispute resolution process where data protection right infringements are processed through mediation, which involve not just compensation but also reform of the data governance rules. Some of these are, I'll say, more advanced than in other countries. But I'm hoping that the consultative committee and the Convention 108 will shed more light on how each of those provisions mean. Because, as you know, in Asia, including Korea, many countries are still struggling to come out of the colonial legacies, or sometimes legacies from past military dictatorship. Under this historical setting, the right to remember and the people's need for more data to participate in civic discourse is very high. Canada and Australia have European-style data protection law. So does Korea, but Canada and Australia allow core judgment databases to be available at no cost, which allow a lot of social innovation, a lot of open discussion about social justice. Korea may have a similar data protection law, yet does not afford that much access to court judgment database. So we need to have, through this accession process, I'm hoping that we can have a more open discussion on the reality on the ground on how data are governed and how the data protection law will help the ultimate goal of the ultimate goal that Convention 108 had, which was protection of human rights. I'll stop there. Thank you.
Thank you, Professor Park, for your sharing the updated information of the Korean environment. So you have one question, specific question to you. So could you reply by chat directly? And I would like to move on to Professor Haga. Professor Yuriko Haga is Associate Professor of Law at Kanazawa University. She specializes in private international law and has written several articles on the cross-border privacy conflicts. Over to you, Professor Haga.
Thank you very much, Professor Miyashita. I'm very honored to be here to join you for the Data Privacy Day. I will describe some situations concerning personal information in Japan. Japan is not at least yet a member of the Convention 108. Our country has no comprehensive supervisory authority on the protection of personal information in the context of the Article 1 Additional Protocol. This should be the barrier to participate in the Convention. Japan has a PPC, Personal Information Protection Commission, standing on the basic law for the personal information, the Act on the Protection of Personal Information. Because of the scope of the PPC's duties is however limited, it may be difficult to deem the PPC as a kind of supervisory authority in the context of the Convention 108. This authority is limited to the extent of the business operators in the private sector and the so-called specific personal information known as the national identification numbers. It should be therefore noted that the authority of the PPC does not fulfill the requirement of the Article 1, Paragraph 2 or Section A of the Protocol. Japanese government drives forward to the usage and traffic of the personal information under the project of the Society 5.0. To the contrary, I have an impression that there is some negative and pessimistic response among the Japanese citizens. The root of this backlash against the information traffic is based on the doubt and fears of the people to personal information usage because the people face too many incidents on the personal information. According to the survey by the Ministry of International Affairs and Communication in 2017, more than 70% of Japanese people feel anxious to provide personal information to companies because of the lack of explanation in advance. The understanding of the privacy can also affect the people's response. Japan borrows the concept of the privacy at first from the United States, whispered in the closet of Warren and Brandeis. The broader concept of the privacy as the right to control self-information is not definitely accepted in Japanese legal practice as judicial doctrine. As a civil law conflict on the personal information, we can assume, for example, unlawful collection of the information, leakage, abuse, and so forth. Because the PPC is not the conflict resolution organization, when an event occurs, the victim will appear to the court to claim the injunction of the unlawful act and the compensation for damages. The court treats the case according to the general laws on the civil liability, specifically called civil. The further difficulty is that, in today's well-informed world, a conflict can easily include international factors, such as one of the parties is foreigner or the data center is located abroad, for example, and the case cannot be simply resolved only by national law. Under this situation, the question of the private international law should be treated before the substantive questions like injunction or compensation. However, the resolution at the private international law level still remains unclear. One problem is the insufficiency of the national legal system. Laws and acts concerning the personal information protection do not enough assume cases with international factors. Also, because the concept of privacy is not solid in Japan, the qualification of the question of violation of personal information is not established in the actual PIL theory. Another problem is that the question of personal information gets public law character in the international trend. The personal information is considered as a fundamental right, such that relevant regulations in the public law field, administrative, penal, or sometimes constitutional. According to this tendency, the question of personal information protection will not always fall in the scope of private international law. The role of the PIL is to adjust the difference and diversity of national civil laws. If the PIL cannot work in the field of personal information protection, only remains the confrontation of diverse national laws. In this context, the Japanese Act has a provision about the extraterritorial application to the cooperation with the foreign authorities, however limited only for the administrative scope. By contrast, civil liability is more complicated because each country has their own values, often conflicting against those of other countries. The typical example is a claim for the disclosure of sender information. Even though Japanese court orders disclosure of the sender located in a foreign country for the reason of the defamation or privacy or intellectual property violation, the foreign court, however, may deny to recognize and enforce the decision standing on the fundamental values such as freedom of speech or secrecy of communication. Considering this chaotic situation, the Convention 108 of a great value. Thanks to the Convention, not only the member states can prepare the internationally harmonized system of the personal information protection, but also, from the viewpoint of private law, member states can share the fundamental idea, which should be a great help to fix national civil law. Today, the information traffic is by nature international because of the technology such as the internet, and the diversity of national legal system impacts are amazing in many aspects. The Convention 108, as a worldwide unified regulation, can be a white knight to this situation. Thank you very much for your attention.
Well, thank you, Professor Haga, for sharing your important aspect of private international law. I am unfortunately aware of the time. We have only a few minutes left. But there is a very important question from Mr. Stuart Dressner from Privacy Laws and Business from the UK in the midnight, probably. So what has happened to the discussions 2 or 3 years ago to seek the interoperability between the GDPR and APEC CBPRs? So there's a big question. So could you reply any of the discussions? Probably Graham may ask you to step in 1 minute to respond these questions.
Thank you, Hiyashi. Well, I'm just trying to drag something out of my memory, and as far as I recall, the European Union some years ago, when it replied to a report that was prepared by a couple of consultants from Australia about interoperability between APEC CBPR and I think it was the directive then, not the GDPR. But the conclusion was that there were almost no points. The conclusion of the EU was that there were almost no major categories on which the two instruments could really be described as equivalent. That the best they could see was that you could have a method of sort of co-compliance where where companies could use one method to work out what they complied with under each of the two separate instruments. But that did not amount to anything remotely resembling interoperability. And I think really the European Commission's adequacy decision concerning Japan was the clearest indicator of the EU's current position on that, when it held that no company that had been certified as complying with the APEC cross-border privacy rules could have that as a justification for re-export of personal data from European data from Japan to that American company or whatever. They were making it very clear that there was no interoperability as far as the EU is concerned. And I'm sorry, those comments are a bit rough, but it's from memory.
Well, thank you very much. I'm sorry, we are running out of time. So may I ask Sophie to conclude final words?
Thank you very much. And despite the discipline and trying to keep to a short timing, we always miss time. I'm very sorry for that. It's 3:30 a.m. in France, and I would have loved to spend the night continue discussing. I've learned a lot. I thank you all very much, our 4 commissioners, our 3 discussants, our 2 masters of ceremony. It was a wonderful way to start the anniversary of Convention 108 for us. So thank you, and the video will be available on our website. Please join me at distance in thanking you all very much. Thank you very much.
Congratulations.